discussion and action, this consideration of our drug and alcohol policy. And we had some public input earlier on that, so we appreciate that. And, let's just go ahead and go to item number 9. And
I'd like to comment on Henry's public comment, if that would be appropriate.
please do.
Henry, I'm all with you on your statement there. And we had a litigation session prior to the meeting to discuss, number one, that issue. And it was brought to my attention that public and private are handled two different ways under the Constitution. And the Fourth Amendment makes it so that it protects individuals from, get me if I'm wrong here, protects individuals from the state or the government infringing on their rights, where a private individual or private company has not as stringent requirements as a government. So going and saying that we're going to have a drug policy that everyone is randomly drug tested, being that we're a government entity, under the Fourth Amendment it says that we can't necessarily do that. Court cases all show that that's a fact. What we've discussed prior to this and we're going to discuss tonight is, you know, how broad can we make that and still stay in that range, that still bring in as many employees as possible for random drug tests. And the key is, and I can't think of the word, safety sensitive positions. My concern is, you know, I think safety sensitive positions can encompass a wide range of individuals. And it goes down to personal, what I personally think is safety sensitive and what somebody else thinks is safety sensitive is two different things. Kind of what we've discussed, and I think we're open for discussion tonight, is what that safety sensitive is. And our idea is of course anybody that's in a position that there is a possibility they could harm other people. So somebody driving a company vehicle, somebody that's on a construction site for the water district, somebody that takes care of the chemicals at the treatment plants. All those people would be safety sensitive. Is the girls that are collecting and working up front, is that safety sensitive? My personal opinion is yes. They may not be physically harming somebody, but there's a possibility that they could harm, you know, their potential to, you know, they have access to personal information that could harm somebody. So that, I mean, that's my opinion, but I'm just 1 out of 5.
A little input on safety sensitive with the federal DOT regulations. I was a truck driver, I wasn't a truck driver, but I was in charge of the truck drivers and the mechanics that worked on the trucks. According to DOT regulations, I had to have the same drug testing, which is more stringent for somebody with a CDL than it is for somebody just a regular worker. Because it's mandated, the federal government mandates that you do that drug and alcohol testing. But I didn't have a CDL, but because I supervised those people, I was required to have, I was in a safety sensitive position.
Right.
I was required to have the same part of the annual alcohol, you know, we did a breathalyzer test and the same split sample drug test,
Mhm.
DOT drug testing, that tested for more substances, and so that's my experience with safety sensitive.
And I think that's kind of where we've gone to, Henry, is we didn't put it in those words that, you know, you're over these guys. But we put anybody that, at least the discussion that we've had at our litigation session was that anybody that drives a company vehicle, anybody, as I said, anybody on a construction site or treatment plant site would be in that safety sensitive, and a flyer flying. So our general manager and our hydrologist, you know, have a potential of going out into the on a construction site, on, you know, going to the rainy gauges. I think where we got kind of held up was, you know, Mary delivers my packet to me in her personal vehicle. Does that constitute a safety sensitive position? And I think we discussed it, that possibly that does, because of she's still under, you know, she's on water district time. However she is using her personal vehicle, she still possibly could be in that traffic accident or whatever. So that's where we're at this point. I think our policy, we've made a couple changes to it, just wordage wise, as far as last chance agreements, how we're going to work those, and the wordage on if you are in a drug rehab program and you come back, that you, if you're not in that safety sensitive position, but you're still, you will be put into the pool for random drug tests because you have had a prior problem with that. So that's kind of where we're at.
I don't know how many people have probably read, probably there are some people in the audience that have read this, I imagine, but maybe, because you're absolutely right, we tweaked it, changed a few things. I don't know whether it would be inappropriate. Could you go through and just highlight the areas where the changes were made, and what the
Sure.
rationale for that was?
Yeah. And there's been no action taken on these things, but we've just talked about it in the context of what legally would be permissible and not subject the district to litigation. One of them is in the definitions section. We've expanded the positive test results to include not only a positive test result by breath, like Henry talked about, not only by urine and blood, but also by any other generally accepted method for testing. And so that would include like, you know, like a swab test, those kinds of things. If you can locate some kind of substance through some other generally accepted test, that would also be included. We also changed section, this is in section 5, it's number 1, with respect to someone coming back after having dealt with the substance abuse problem. If they were not terminated and they were allowed to come back, we changed the may be required to submit to a drug and alcohol testing that they will be or must be. We also changed section 5, part 2, which goes along with that definition, so that we're going to expand that to include any generally accepted testing procedure. And then finally, Kenyon talked about a last chance agreement. What we're going to do is we're going to include a sample last chance agreement of what it would look like if an employee was given a final opportunity to you know, deal with whatever issue it was, problem they had. This is the kind of last chance agreement that would be used in that situation. That would be prepared initially by staff, and then it would be subject to board approval. And those were the changes that we tentatively talked about. And so it would be, you know, open for the board to make a motion to see if you wanted to accept the policy with those additions.
I think the only thing that I can see that we have left is defining the safety sensitive. And I think, you know, I'm ready to accept this as is, as long as you think it's appropriate that we define this safety sensitive in this situation.
Yeah, we do have a definition of safety sensitive. It's in part 12, or paragraph 12 of the definitions. And what we have there, I think, essentially captures what you guys had talked about, and Kenyon touched on this a couple of times. A is any employee that operates a district vehicle or operates a private vehicle while on district business. If that's being done on a regular or recurring basis, then they would be considered to be in a safety-sensitive position. And then all of the other things that Kenyon was summarizing, anything that would involve potential harm to someone's safety, if they were inattentive, if they made an error in judgment, dealing with dangerous tools or equipment, dangerous chemicals, some of those things would be applicable to the district, and anybody in that situation would be considered to be in a safety-sensitive position.
Right, but I thought we were gonna, and this addendum is gonna spell out those positions.
Correct, yeah, Exhibit A is
You've got-
going,
Do you have Exhibit A, or?
yeah, we have, no, we don't have it. The purpose of today would be for you guys to decide, and
That's
and I
right.
think,
That's what I'm trying.
yeah, based on what you guys have talked about, I think we probably have a pretty good idea. I think Kenyon said essentially everybody except for maybe the girls and maybe the accountant, and when I say the girls, I mean the ladies that work up front that don't on a recurring basis use their vehicle. There might be one or two of them that don't, but it sounds like every other employee would be in a safety sensitive position. So it might be easiest just to say which ones will not be considered safety sensitive, and we can prepare Exhibit A saying everybody, and we'll outline every position with the exception of those two that are not.
Okay, so you're comfortable with providing that as the addendum?
Yeah, I mean, I think you guys should probably
Adopt
define,
Adopt the policy and then have the addendum added later, is that what you said?
yeah, I think you guys can approve the policy, just give me direction to say it's gonna be everybody except those two positions at the front, or whatever that is. I'm not even sure I know
The
exactly.
account looks like he may have dropped a few pounds, so we may want to look into that.
Sign me up. If I might go, a couple of things, just, and I'm not, don't have a total clear picture on total operation, but a couple of things. I do know that I have had an occasion to use a company vehicle, but it's not regular or recurring, it's just go to an event, you know, that kind of thing. So that happens now and again. I also know that the girls up front, staff that accepts money, we have collection boxes, for example, on the receivable side, where money's being deposited at the credit union, power company, and so forth, and that money, those deposits are obtained, and Mary's not typically the one that does that, it's somebody else is doing that, you typically using their own vehicle again. So I mean, I'm not lobbying, yeah, they go up and make bank deposits as well, so if I'm the bad guy saying, almost everybody falls into that category.
Yeah, and the court cases defining safety sensitive, they differ across the country. Some of them say that, very little use of a vehicle would be sufficient to constitute safety sensitive. Others say that, what would almost be considered substantial use of a vehicle is not. So we've got to try to strike a balance there. I think that we're gonna be able to accomplish what the board has expressed over the last, couple of meetings. If these girls these positions are going and picking up money or dropping deposits on a regular basis, then I think that they would fit, under the definition that we've put in here. So it might include everybody. Are there, Wes, are you the only employee that is not using a district vehicle or private vehicle
Probably.
to engage in district business?
And it's not unreasonable to think that I could be required or participate in making deposits and/or picking up funds from there as well. So I'm not
Unless you were doing it on a somewhat recurring basis, though, I think we would be going too far. I would be concerned about the potential litigation, you know.
Sounds like to me, everybody but the accountant.
Yeah. All right, somebody make a motion.
Mr. President,
Yes, sir.
Mary's more in tune with how many people go out and when. Would it be fair to say that all the administrative staff equally participate in picking up deposits and going to the bank?
As far as I know, yeah.
Yeah, I thought so too. That's what I told you earlier, but
And they drive, they're out more than me, so.
yeah, I think that it's pretty well evenly distributed with, every couple days, somebody goes out and does something.
Well, I think if, and once again, I think if that's the case, I think from our policy that we have here, I think the only one that doesn't cover is our accountant.
Yeah, so we'll have to keep a very close eye on him.
Yeah.
Yeah, I
In
think
our-
that's right.
In our addendum, then we need to put, check on the accountant every 6 months.
Okay, in light of that discussion, are we ready to make a motion?
I'll make a motion.
Okay.
I'll make a motion that we accept the drug policy as with the changes that we have made, and with the Exhibit A attachment to be put on there. That's my motion.
Exhibit A attachment being essentially all the positions listed except for the accountants.
Correct.
Okay.
I'll second it.
Okay, we have a motion and a second, all in favor? Okay, we have 5 in favor, none opposed, so the motion carries, and